Rule 66 Co Warranto. In Latin, co warranto means by what right or authority. It is a special civil action brought in the name of the Republic against the usurpation of public office, position, or franchise, and commenced by the filing of a verified petition. It may also be brought by an individual in his own name who claims to be entitled to a public office or position usurped or unlawfully held or exercised by another. Which courts have jurisdiction over petitions for quo warranto? The Supreme Court, the Court of Appeals, and the regional trial courts have original and concurrent jurisdiction. The Sandigan Bayan has original jurisdiction in quo warranto arising in cases filed under Executive Order numbers 1, 2, 14, 14A in aid of its appellate jurisdiction. Section 4 PD number 1606. What is the venue in quo warranto proceeding? If brought before the RTC, it should be filed with the RTC exercising jurisdiction over the territorial areas where the respondent or any of the respondents resides. If the action is commenced by the Solicitor General, it may be brought in a RTC in Manila, in the Court of Appeals, or in the Supreme Court. Section 7, Rule 66. Q. Mandamus is also available against a person who unlawfully excludes another from the use and enjoyment of a right or office to which such other person is entitled. Distinguish this type of mandamus from quo warranto. Where the respondent merely excludes the petitioner from an office without usurping, intruding into, or unlawfully holding the office, the proper remedy is mandamus. If the respondent, however, claims any right to the office and usurps, intrudes into, or unlawfully holds it against the petitioner, the proper remedy would be quo warranto. Burgett v. Mayor, 94 Phil, 930. Q. Petitioner Fabian was appointed election registrar of Municipality of Sevilla, supposedly to replace the respondent election registrar Pablo, who was transferred to another municipality without his consent and who refused to accept his aforesaid transfer, much less to vacate his position in Bogo town as election registrar, as in fact he continued to occupy his aforesaid position and exercise his functions thereto. Petitioner Fabian then filed a petition for mandamus against Pablo, but the trial court dismissed Fabian's petition, contending that quo warranto is the proper remedy. Is the court correct in its ruling? Why? Yes, the court is correct in its ruling. Where the respondent merely excludes the petitioner from an office without usurping, intruding into, or unlawfully holding the office, the proper remedy is mandamus. If the respondent, however, claims any right to the office and usurps, intrudes into, or unlawfully holds it against the petitioner, the proper remedy would be quo warranto, Burgett v. Mayor. Here, Pablo refused to vacate his position and continued to hold it against Fabian. Hence, quo warranto, not mandamus, is the proper remedy. Q. Against whom may a quo warranto case be brought? Against a person who usurps, intrudes into, or unlawfully holds or exercises a public office, position, or franchise. Number 2. A public officer who does or suffers an act which, by the provision of law, constitutes a ground for the forfeiture of his office, or an association which acts as corporation within the Philippines without being legally incorporated or without lawful authority to act. Note, however, that a quo warranto proceeding in the third case is within the regional and exclusive jurisdiction of the Regional Trial Court pursuant to Section 5.2 of the Securities Regulation Code. In relation to Section 5, letter B of PD number 902-A, which speaks of a controversy between a corporation and the state insofar as it concerns the corporation's franchise or right to exist, see also AM number 030303 SC effective 1 July 2003. Q. A group of businessmen formed an association in Cebu City calling itself Cars Company to distribute sales cars in said city. It did not incorporate itself under the law, nor did it have any government permit or license to conduct its business as such. The Solicitor General filed before a regional trial court in Manila a verified petition for quo warranto, questioning and seeking to stop the operations of Cars Company. The latter filed a motion to dismiss the petition on the ground of improper venue, claiming that its main office and operations are in Cebu City and not in Manila. Is the contention of Cars Company correct? Answer is no. Under Section 7, Rule 66, when the Solicitor General commenced the action for quo warranto, it may be brought in the Regional Trial Court of Manila. Note, with the passage of AM number 0303 Supreme Court, effective July 1, 2003, original and exclusive jurisdiction over the action for quo warranto under Section 1, Rule 66 has been vested in the regional trial court designated by the Supreme Court. Hence, the action should now be filed in the regional trial court having jurisdiction over Cebu City. Classify quo warranto. Quo warranto may be compulsory or discretionary, brought in the name of the Republic, Section 166, or in the name of a private individual, Section 566. When is quo warranto compulsory? The Solicitor General or a public prosecutor, when directed by the President of the Philippines or when upon complaint or otherwise, he has good reason to believe that any case specified in Section 1, Rule 66 can be established by proof, must commence the action. When is quo warranto discretionary? The Solicitor General or a public prosecutor may, with the permission of the court in which the action is to be commenced, bring such an action at the request and upon the relation of another person. But in such case, the officer bringing it may first require an indemnity for the expenses and costs of the action in an amount approved by and to be deposited in the court by the person at whose request and upon whose relation the same is brought. Who may commence a quo warranto action? The Solicitor General, a public prosecutor. Number 3, a person claiming to be entitled to a public office or position usurped or unlawfully held or exercised by another may bring an action, therefore, in his own name. Distinguish a quo warranto action commenced by a private individual from a quo warranto action commenced by a Solicitor General or public prosecutor. In an action commenced by the private individual, it is necessary for the petitioner to prove his right to the office in dispute. If he fails to prove this, it is unnecessary for the court to pass upon the right of the respondent to the office. In an action commenced by the Solicitor General or a public prosecutor, it is not necessary that there be a person claiming to be entitled to the office alleged to have been usurped. The duty of the court is to pass upon the right of the respondent only. R.A. 10600 or R.A. 10660 created 6 new vacancies in the Sandiganbayan. The JBC submitted 6 groups of or clusters corresponding to each vacancy to President Aquino for his consideration. Petitioners are members of one of the clusters. However, not one from their cluster was appointed by President Aquino. They filed a petition for quo warranto challenging the appointment of the SB justices by Aquino. They alleged that the President violated the Constitution when he disregarded the JBC's clustering by not appointing any one of their clusters to the Sandiganbayan. Will the action for quo warranto prosper? The answer is no. It is axiomatic that in a petition for quo warranto filed by an individual claiming entitlement to office, such individual must show that he has a clear right to the office allegedly held by another. petitioner judges who merely have an expectant that a clear right to Sandiganbayan positions are not proper parties to file petition for co-warranto under Section 5, Rule 66. Petitioners' rights depended on an expectancy that they would be the ones appointed by the President. Aguinaldo versus Aquino, 29 November 2016. Leonardo de Castro. In the co-warranto case filed by the Republic against Maria Lourdes Sereno, seeking her ouster from the position of Chief Justice of the Philippines, certain private individuals filed motion for leave to intervene as citizens and as taxpayers. They claim that as citizens and as taxpayers, they have a legal interest in the matter of Sereno's ouster or removal. May these individuals be allowed to intervene? The answer is no. The movants do not possess the required legal interest to intervene in a co-warranto suit against, and since they neither claim to be entitled to the questioned position, nor are they once charged with the usurpation thereof. Republic versus Sereno, May 11, 2018. Q. In an action for usurpation, can the court award damages sustained as a result of the usurpation to the person adjudged entitled to the office? No. Such damages must be sought in an action to be filed within 1 year after the entry of the judgment, establishing the petitioner's right to the office in question. See Section 9, Rule 66 in relation to Section 11, Rule 66. Q. In an action for usurpation, what judgment shall the court render if usurpation is found? The court shall render judgment that such respondent be ousted and altogether excluded therefrom, and that the petitioner or relator, as the case may be, recover his costs. Such further judgment may be rendered determining the respective rights in and to the public office, position or franchise of all the parties to the action as justice requires. Q. What is the prescriptive period for bringing a co-warranto action affecting title or public office? The action must be brought within 1 year after the case of or cause of such ouster, or the right of the petitioner to hold such office or position arose. Q. In the co-warranto case filed by the Republic against Maria Lourdes Sereno, seeking her ouster from the position of Chief Justice of the Philippines, the respondent moved to dismiss the petition on the ground of prescription invoking Section 11, Rule 66, which provides that nothing contained in this rule shall be construed to authorize an action against a public officer or employee for his ouster from office unless the same be commenced within 1 year after the cause of such ouster or the right of the petitioner to hold such office or position arose. May the petition for quo warranto be dismissed on the ground of prescription? No, the 1 year limitation is not applicable when the quo warranto action is filed by the state at its own instance through the Solicitor General. Here, the petitioner is not a mere private individual pursuing a private interest, but the government itself seeking relief for a public wrong and suing for public interest. Republic versus Sereno, May 11, 2018. However, the 1 year prescriptive period shall apply to a quo warranto action even if filed by the Solicitor General or public prosecutor, but that they request it upon relation of another person. The same case. What is the prescription or prescriptive period for bringing an action for damages sustained by the person adjudged entitled to the office as a result of the usurpation? Within 1 year after the entry of the judgment establishing the petitioner's right to the office in question. Q. If the principal of a public high school is illegally replaced by another, is it a requirement that before he can go to court on quo warranto, he should first exhaust administrative remedies? No, it is not a requirement that he should first exhaust administrative remedies. The Supreme Court has held that in quo warranto proceedings, no one is compelled to exhaust administrative remedies since public interest requires that the right to public office should be determined as expeditiously as possible. Furthermore, the action for quo warranto must be brought within 1 year from the date of ouster. Galano versus Rojas. Q. A quo warranto judgment directing the reinstatement of respondent as regional director of the National Commission on Indigenous Peoples became final and executory. However, it was later discovered that the respondent had falsified his bachelor's degree and thus had become ineligible for the position of regional director. May the judgment still be executed? The answer is no. The general rule is that the execution of a court's judgment becomes a matter of right upon the expiration of the period to appeal, and no appeal was duly perfected. Generally, therefore, courts may no longer review or modify a final and executory judgment. This is otherwise referred to as the principle of immutability of judgments, which dictates that once a decision becomes final, the enforcement or execution of the judgment becomes a purely ministerial act. An exception to the rule is whenever circumstances transpire after the finality of the judgment, rendering execution unjust and inequitable. Here, there was a supervening circumstance, that is, the discovery that the respondent had falsified his bachelor's degree and thus had become ineligible for the contested position. To still order the execution of the judgment would be clearly unjust and inequitable. Arroyo versus CA. Rule 67. Expropriation. Define eminent domain and expropriation. Eminent domain is the right of the state of the sovereign to take private property for public use upon payment of just compensation. Expropriation is a special civil action by which the state or the sovereign exercises its right of eminent domain. In other words, eminent domain is the right, while expropriation is the judicial proceeding for enforcing that right. What entities may exercise the power of eminent domain? The state. Local government. Section 19 Local Government Code. There must be an ordinance passed by the LGU. A mere resolution will not suffice. Number 3. Public utilities when authorized by their franchise. So which court has jurisdiction over an action for expropriation? Jurisdiction over eminent domain cases lies with the regional trial court. An expropriation case is one whose subject matter is incapable of pecuniary estimation. The subject of an expropriation case is the determination of the government's right to take private property for public use. Barangay San Roque versus Pastor, GR 138896. What are the stages of an expropriation suit? The first stage is the determination of the plaintiff's authority to expropriate, including the inquiry into the propriety of the expropriation, its necessity, and the public purpose of the expropriation. The court will issue an order of expropriation declaring that the plaintiff has the right to expropriate for the public use or purpose described in the complaint and upon the payment of just compensation. The second stage is the ascertainment by the Court of Just Compensation, taking into account the report of the commissioners. The court shall render judgment in accordance with the action it has taken upon the report. How is the right of eminent domain exercised? The right of eminent domain shall be exercised by the filing of a verified complaint, which shall state with certainty the right and purpose of the expropriation, describe the real or personal property sought to be expropriated, and join as defendants all persons owning or claiming to own or occupying any part thereof or interest therein, showing, so far as practicable, the separate interests of each defendant. If the title to the property is in the name of the Republic, may an action for appropriation lie? Yes. If the title to any property sought to be expropriated appears to be in the Republic of the Philippines, although occupied by private individuals, or if the title is otherwise obscure or doubtful, so that the plaintiff cannot with accuracy or certainty specify who are the real owners, averment to that effect shall be made in the complaint. When shall the plaintiff have the right to enter or take the possession of the property subject of the expropriation? In case of real property, upon the filing of the complaint or at any time thereafter, and after due notice to the defendant, the plaintiff shall have the right to take or enter upon the possession of the real property involved if he deposits with the authorized government depository an amount equivalent to the assessed value of the property. Such deposit shall be held by such bank, subject to the orders of the court, and shall be in money, unless in lieu thereof the court authorizes the deposit of a certificate of time deposit of a government bank of the Republic payable on demand to the authorized government depository. In case of expropriation of right of way, site, or location for national government infrastructure projects, upon the filing of the complaint or at any time thereafter and after due notice to the defendant, the implementing agency shall immediately deposit to the court in favor of the owner the amount equivalent to the sum of 100% of the value of the land based on the current relevant zonal valuation of the Bureau of Internal Revenue, issued not more than 3 years prior to the filing of the expropriation complaint, subject to subparagraph C of this section. Number 2. The replacement cost at current market value of the improvements and structures as determined by the implementing agency, a government financial institution with adequate experience in property appraisal, and an independent property appraiser accredited by the BSB. The current market value of crops and trees located within the property is determined by a government financial institution or an independent property appraiser to be selected as indicated in Section 5, letter A of RA number 10752. Upon compliance with the guidelines above mentioned, the court shall immediately issue to the implementing agency an order to take possession of the property and start the implementation of the project. In case of expropriation by a local government unit, the local government unit may immediately take possession of the property upon the filing of the expropriation proceedings and upon making a deposit with the proper court of at least 15% of the fair market value of the property based on the current tax declaration of the property to be expropriated. How about in case of personal property? If personal property is involved, its value shall be provisionally ascertained and the amount to be deposited shall be promptly fixed by the court. After the deposit is made, the court shall order the sheriff or other proper officer to forthwith place the plaintiff in possession of the real or personal property involved and promptly submit a report thereof to the court with service of copies to the parties. The court shall issue a writ of possession for this purpose. Otherwise, the plaintiff shall have a right to enter upon the property only upon payment to the defendant of the compensation fixed by the judgment, with legal interest therefrom, from the taking of the possession of the property or after tender to the defendant of an amount so fixed and payment of the costs. Is a prior hearing required before the plaintiff may enter into or take possession of the property involved? No. What is required under Section 2, Rule 67 is due notice to the defendant, but not a hearing. What is a responsive paper or pleading which the defendant may file in an expropriation suit? Notice of appearance and manifestation. If a defendant has no objection or defense to the action or the taking of his property, he may file and serve a notice of appearance and a manifestation to the effect, specifically designating or identifying the property in which he claims to be interested within the time stated in the summons. Thereafter, he shall be entitled to notice of all proceedings affecting the same. Answer. If a defendant has any objection to the filing of or the allegations in the complaint, or any objections or defense to the taking of his property, he shall serve his answer within the time stated in the summons. The answer shall specifically designate or identify the property in which he claims to have an interest, state the nature and extent of the interest claimed, and adduce all his objections and defenses to the taking of his property. May counterclaim, cross-claim, or third-party complaint be alleged in the answer? The answer is no. No counterclaim, cross-claim, or third-party complaint shall be alleged or allowed in the answer or any subsequent pleadings. What is the result if a defense or objection is not alleged in the answer? A defendant waives all defenses and objections not alleged in the answer. The court, however, may, in the interest of justice, permit amendments to the answer to be made but not later than 10 days from the filing of the answer. Note, however, that at trial of the issue of just compensation, whether or not a defendant has previously appeared or answered, he may present evidence as to the amount of the compensation to be paid for his property, and he may share in the distribution of the award. Can the defendant in an expropriation suit file a motion to dismiss? No. While under the 1964 rules, the defendant in an expropriation case may file a motion to dismiss. Under the 1997 Rules of Civil Procedure, the defendant may no longer file a motion to dismiss. Any objections or defenses the defendant may have to the taking of his property must be set forth in an answer. Masiki versus City of Pasig. Q. The Republic of the Philippines, through the Department of Public Works and Highways, filed with the RTC a complaint for the expropriation of the parts of land owned by Jovito. The land is to be used as an extension of the National Highway. Attached to the complaint is a bank certificate showing that there is on deposit with the Land Bank of the Philippines an amount equivalent to the assessed value of the property. Then DPWH filed a motion for the issuance of a writ of possession. Jovito filed a motion to dismiss the complaint on the ground that there are other properties which would better serve the purpose. Will Jovito's motion to dismiss prosper? B. As judge, will you grant the writ of possession prayed for by DPWH? Explain. Answer to letter A. Jovito's motion to dismiss will not prosper. The Supreme Court has held that the defendant in an expropriation case cannot file a motion to dismiss but should raise his objections in the answer. Letter B. As judge, I will not grant the writ of possession prayed for. In case of expropriation for national government infrastructure projects, the law requires that the government, in order that you will have the right to enter or take possession, should immediately pay the owner of the property 100% of the market value of the property. Here, what was done was only to make a deposit of an amount equivalent to the assessed value. When shall the order of expropriation issue? If the objections to and defenses against the right of the plaintiff to expropriate the property are overruled, or when no party appears to defend, the court may issue an order of expropriation declaring that the plaintiff has lawful right to take the property sought to be expropriated for the public use or purpose described in the complaint and upon the payment of just compensation. Is a hearing required before the order of expropriation may issue? It depends. If the defendant has no objection or defense to the action or the taking of his property, or if no party appears to defend, the court may issue the order of expropriation without a hearing. Otherwise, a hearing shall be conducted. May the order of expropriation be appealed? Yes. A final order sustaining the right to expropriate the property may be appealed by any party aggrieved thereby. Such appeal, however, shall not prevent the court from determining the just compensation to be paid. What is the time and manner for appealing an order for expropriation? The party taking the appeal shall file a notice of appeal and a record on appeal within 30 days from notice of the order of expropriation. Municipality of Binan versus Garcia. This is because the appeal from the order of expropriation is a separate appeal. What is just compensation? Just compensation is the market value of the property plus consequential damages to the property not taken, less the consequential benefits to be derived from the owner from the public use or purpose of the property taken. The consequential benefits assessed shall in no case exceed the consequential damages assessed. This is to avoid the property owner being deprived of the actual value of his property. The following equation is illustrative. FMV, fair market value, plus consequential or CD minus CB. CD minus CB is consequential damages to the property not taken, less the consequential benefits to be derived by the owner from the public use or purpose of the property taken, the operation of its franchise by the corporation or the carrying of the business of the corporation of person taking the property, and then that is the equals to your just compensation. What is meant by consequential benefits? A consequential benefit refers to the actual benefits derived from the owner on the remaining portion of his or her land, which are the direct and proximate result of the improvements consequent to the expropriation and not the general benefits which he receives in common with the community. At what point in time is the just compensation to be determined? The just compensation is determined as of the date of the taking of the property or the filing of the complaint, whichever comes first. The City of Cebu filed the complaint for expropriation of the respondent's property on September 17, 1993, but the property was actually taken by the city only on 21st of September 1994. At what point in time should the just compensation be determined? As of the taking of the property on September 21, 1994, while Section 4, Rule 67 provides that just compensation shall be determined at the time of the filing of the complaint. If the filing precedes the taking, such provision cannot prevail over Section 19 of the Local Government Code, a substantive law, which states that just compensation be based on the fair market value of the property at the time of the taking of the property. City of Cebu versus De Damo, May 7, 2002. Davide C.J. I will read more examples on Rule 67 before moving to Rule 68. And thank you so much, guys, for your support. I guess I get inspired when I see you guys are subscribing to the channel. And if you leave comments or maybe a thumbs up, that would really greatly help. Thanks.